Hello everyone, welcome back on LegalEase. Today we are going to discuss on the topic of misjoinder and non-joinder. In the last video, we discussed the joinder of parties and different examples related to it, which is given from Rule 1 to Rule 7. Today, misjoinder and non-joinder is related to majorly that particular topic is given under Rule 9. So we will be discussing that particular rule and we will be discussing the meaning of misjoinder, meaning of non-joinder, and the other concepts related to the definition of misjoinder and non-joinder. So for that, first of all, the meaning of misjoinder. So misjoinder means when the parties have been added in the suit who are neither necessary nor proper parties, and non-joinder is when either necessary or proper party is not added in the suit. So by the reading this particular definition, you might have now understood that for understanding these two terms, we have to understand the meaning of necessary party and proper party first. So we'll first understand the meaning of that. So what are necessary and proper parties? Necessary parties are those parties whose presence is essential in a particular suit, against whom the relief is sought, or who has the right to claim the relief, without whom an effective order cannot be passed. Effective order in the sense the order that can be executed or cannot, that can be executed without challenging the validity of the same. I'll explain it by the meaning also. In absence of necessary party, no decree can be passed. If decree or order is passed, it will not be executed. Why? In case of a proper party, it is a party who has an interest in the suit, but an effective order can be passed without his presence as well. So what does that mean? So basically a party, if is not present in the case and if not heard in the case, the decision that comes, either that decision is against that particular party and therefore violates the right of that particular party, and therefore that particular party can challenge the validity of the decision. So that party will automatically become a necessary party, or who also has a right to claim the relief, but since that party was not made as a party in that suit, therefore, again, the decision can be challenged, will become a necessary party. For example, in a partition suit, all the people who have a direct right to claim, let's say A is the father who has three children, B, C, and D. All these three people have a right over the properties of A. So if a suit is filed between B and C and D is not added and it is a partition suit, the suit will be, so here D will become the necessary party, and if suit is decided, D will have the power to challenge the decision because he has not got his share and only B and C has got the share. Without the presence of D, an effective order cannot be passed, or if it is passed, it can be challenged and therefore it cannot be executed. So therefore all the people will become a necessary parties. While in the same case, the proper parties will be, so these, let's say these B, C, D that we have talked about, these B, C, D have further children and grandchildren. So again, let's take an example of B. So B has, B has X and Y, and X and Y has X, S. Okay. C has a M and M has a daughter N. D has a son S and he has a daughter D. ठीक है, इस तरीके से there are other people as well. So now all these parties, we are considering a case wherein B, C, D are alive. So, and this is a property which is to be partitioned. When B, C, and D are alive, they are the necessary parties. All these are the proper parties who have interest in that property, but not a direct interest. If they are not added or not heard, it is not going to change the decision or impact their rights. So their right will not be violated if they are not added. However, their presence can help the court in deciding the matter more effectively. So an effective decision and a more effective way of deciding a particular case will be possible by adding this particular party. So that is the intention of adding any proper party. I hope this is clear to you, the meaning of a necessary and a proper party. For more understanding, let's take another example. Let's say there was an appointment made of a person in a a person was appointed in a government department, and this person was removed from this particular department. And now this person, after his removal, some other person B. So let's say this is a person who was appointed and then removed, and some other person B was appointed at his place. Now this A challenged his appointment removal on certain grounds against the government department. which appointed him and removed him. And the case was, and the court decided ultimately in favor of A, and the court said that he should be reinstated into the service. Now, if he is reinstated into the service, that means the court also said the person who was appointed at his place should be removed. Now, if he is to be removed, B is to be removed. So A did not want to get any remedy against B. He just wanted a remedy against this department and the disciplinary action which was taken against him. So all the people involved in it, but did not want anything from B. But this decision is impacting B's right also, B's interest as well, because B will be removed. His principle of natural justice will be violated because he was not given a right to be heard. That's why in this case, B will become a necessary party, and without adding this person, the decision cannot be given, or it will not be an effective decision and cannot be executed. So that is how you determine a party as a necessary party or a proper party. For a better understanding, you can read the case of Ramesh Hirachand, which I have mentioned in the description box as well. It's a very important case and a landmark case to determine the meaning of necessary party, proper party, and a witness. So this can be referred. Now, the Chhattisgarh State Electricity Board, and there are other lot of cases in which the test for necessary party was given, where it was said that necessary party is a party who there must be a right to relief, who will have a right to relief or against whom the right to relief is claimed. And we will see it is not possible to pass an effective decree in absence of such party. If both these things are there or any of these things is there, then the party will be considered as a necessary party. So first we will see whether the party has a right to relief or against whom the relief is claimed, or second one is whether an effective decree can be passed in absence of that party. If effective decree can be passed, it is not a necessary party. If it cannot be passed, then it is a necessary party. And similarly, if the party has a right to relief, it is a necessary party, or against whom the right to relief is asked, then it is a necessary party. Otherwise, it is not a necessary party. So I hope necessary party and proper party is clear to you. Now we'll go to the misjoinder and non-joinder. So misjoinder is defined as the parties added in a suit are neither necessary nor proper, and non-joinder is when neither necessary nor proper party is joined. So again, I'll discuss it with the examples. First, I'll explain it. Let's say in a case, A and B are the necessary party, C is a proper party, and D is a party which is neither necessary nor proper. So if a suit is filed, A, C versus B and D, then it is a case wherein there are necessary and proper parties added, but a party is also added which is neither a necessary party nor a proper party. So it is neither one of them. So that's why it is a case of misjoinder. So misjoinder is where a party have been added in the suit who are neither necessary nor proper. So अगर कोई party ना तो necessary ना proper है तो वो misjoinder का case हो जाता है. If we talk about non-joinder, that means either necessary or proper parties has not been added. In the same case, let's take an example. There is a suit between C versus B and D. ठीक है, तो D की वजह से तो misjoinder हो गया. Let's say there is no D. ठीक है, just to make it more clear, there is no D. It is only C versus B. In this case, A is also a necessary party, and A is not added, so it is a non-joinder of necessary party. Or if let's say there is A versus B, then it is C is not added and C is a proper party, so it is a case of non-joinder of proper. Now, why it is important? Because Rule 9 of CPC talks about the consequences of non-joinder and misjoinder. And it says the suit will not be dismissed because of the misjoinder or non-joinder of a party. However, there is a proviso which says if there is a non-joinder of a necessary party, then the suit can be dismissed. मतलब सूट वो जो होगा वो invalidate हो जाएगा, the suit will be invalid. So we have already seen that without necessary party the decree will be invalid, the suit will be invalid. So the same thing is given here also. So if this is the suit C versus B, then in this case there is a non-joinder of a necessary party which is A, this suit will be dismissed. So that is the impact of misjoinder and non-joinder, which is given under Rule 9. The objection to misjoinder and non-joinder is also given, which is given under Rule 13, which says that if there is a case of misjoinder and non-joinder in a suit, the objection to it should be raised at the earliest possible opportunity, or in case of the settlement of the issues at or before such settlement. This again is the same language as that of section 21, as well as section 20. for which we discussed in transfer of suits, objection to jurisdiction and transfer of suits. So again, this has to be raised before, until and unless the ground of raising that objection has arose later. For example, one of the necessary party has got birth after the settlement of the issue, then you will add that party only after the settlement of the issues. Otherwise, the name should be added, or objection related to the addition of the name should be raised beforehand. So that is rule 13. This is it related to non-joinder and misjoinder of parties. In the next video, we'll discuss the representative suit, which is also given under Order 1, and another concept of striking off and adding of the parties, which is mostly applicable in case of misjoinder and non-joinder of parties. So if case of any doubt, please mention it in the comment section. And for more such videos, stay tuned to LegalEase. Thank you so much and have a nice day.